it is. Okay, thank you. All right, if the attorneys will please place their appearances on the record.
Afternoon, Your Honor. Christina Stifler, Ms.
All right, so we have a few motions, and I want to know kind of where the parties want to start.
Had some discussions with the defense counsel, Mr. Carodi, regarding the defense motion to exclude testimony of minor child BB.
Was that adopted by Fernandez too?
It was, Your Honor. I've had discussions with Mr. Dreiser as well. The state's position is at this time the motion is not ripe to be heard. It's not a constitutional suppression motion. It's a motion to exclude testimony. The state has told Mr. Carodi and Mr. Dreiser we would like the opportunity to sit down with the minor child BB, speak with her ourselves, determine if we believe we will call her certainly as a witness at trial or not. If we do make the decision to call her as a witness at trial, I think both sides would agree that a competency hearing would need to be held at that time.
Mr.
The court can rule on this motion without conducting that analysis and without hearing from BB themselves.
Do you agree with that?
Partially, Judge. I do think the court can rule based on Section 403 and 604, 403 and 604 as articulated in the motion regarding the minimal probative value of her testimony and using the evidence that we attached, which is the forensic interview that was done with her, I believe, 2 days after the incident. So there are two grounds. Your Honor, the first one we don't believe involves BB. That is your consideration of the probative value of her testimony and whether or not it's outweighed by unfair prejudice. That argument is simply that there's no dispute that BB was in the car at the time that Mr. Bridegan was murdered. There's no dispute that she was 2 years old at the time. There's no dispute that she was in a rear-facing car seat in the back passenger side of the vehicle. There's a picture attached to our motion as well that shows her car seat in the position that was an ET photo. There are several scene witnesses that took BB out of the vehicle, and BB's the one thing that we believe BB would add based on her forensic interview that's before the court is that she heard booms. There is surveillance footage that captures the gunshots in this case. And there is no dispute that Mr. Bridegan was shot. And so our position is that on a 403 and 604 ground that she's two, she was in a rear-facing car seat. There's a forensic interview of her where the only thing that's probative at all is that she heard booms, and Daddy got sick, I think is what she's saying. And, Your Honor, there's simply no dispute that she was present in the rear-facing car seat. And so there's minimal value in parading a very young child into a trial of this magnitude. And so we would ask that the court, without further information, without further evaluating the child's competency, just make the call. Now, if the court's unwilling to do that, we do have competency concerns. She's a very young child, but we agree with the state that the first step in that, the state has indicated to us that they are not sure that they're going to call her. And so if they do not intend to call her, then there's no purpose in going forward with a court-appointed expert to evaluate the child's competency. And there's no point in us trying to depose the 6-year-old child now.
So just a couple of things. I understand what the defense is proposing to me. However, I looked back at the indictment, there's count 4 where BB is named. And so exclusion of potential quote unquote victim testimony, I think, to just automatically rule, I'm going to wait, I think, to see if it's offered, right? So just across the board, exclusion of witness testimony is a harsh remedy / sanction. If I needed to do the analysis, I'll do it if the state says that they're going to offer it. So I'll just hold this one, okay? I think
Sure.
that's,
I would ask that the court set a deadline for the state to make the call as to whether they are going to call her as a witness. A very reasonable deadline, sometime in June, give them more than a month. But I think that we need trials coming up.
no, I agree. We're running out of runway. So when does the state believe that you're going to make the call?
I've told Mr. Caridi that I intended to speak with her in June. We've been heavy in our depot's schedule in the month of May and obviously preparing for these hearings. We've not had Mrs. Bridegan, BB's mother, they are out of town, so I have not had the chance to coordinate with her. But if the court wants to set a deadline at the end of June, that's fine with the state.
No, sooner than that. June 15th.
We have the following week. I'll be out the week of the 8th. And 22nd.
So what I'm hearing, so let's say hypothetically, the state does intend to call her. Someone wants to do a forensic evaluation.
No, if they don't intend to call her.
No, I said if.
If, I think the law demands it at this age, that there has to be an independent forensic evaluation ordered by the court regarding her competency. She was 2 years old at the time. Competency is judged at the age at the time of trial, which is 6, but the law is pretty clear that 6-year-olds have to be evaluated for competency.
Your Honor, I believe the court makes that determination.
In a hearing. What are you citing?
Competency to stand trial, it's competency to testify, which is the court would undergo an inquiry with the child in court of whether she has the ability to understand the difference between right and wrong, a truth and a lie, can present testimony in a coherent narrative manner.
I don't want to push. But I feel like I have to, okay? It's May 13th. If I wait to June 22nd, y'all have not taken a deposition, correct, of BB?
They have not, no.
Be correct.
Right, and so when would you all, so let's say I wait to June 22nd, when would you all be able to accomplish that? And then this court have a hearing?
June 18th then, Your Honor. That gives me the week of, I'll return obligations the week prior, and that'll give me enough time.
Understand.
By the 18th, I'll have an answer for defense counsel as to whether we believe we'll call her.
June 18th?
Yes, ma'am. That's that.
Sorry, but I just don't know, I mean, this has a domino effect on everyone's schedule, and then there'd just be no way to get it accomplished. So June 18th will be the deadline.
Thank you.
Thanks.
And Judge, the case that I was citing for the independent forensic evaluation is
Yes.
Lloyd versus State. That's Florida Supreme Court, 524 Southern 2nd, 396. And in that case, I don't know that it's required, but the defendant did motion. The court granted it.
Wait. 520, is Lloyd,
Lloyd versus State,
was it recently decided?
1988,
1988, okay. I'm thinking another one. 524 Southern 2nd,
396.
396. Thank you. I'll look at it, but if I'm going to hold it, then I'll read it.
Yes, Judge.
Okay. So this was for the forensic evaluation?
That, and we're motioning for that, I guess, as opposed to saying that it's absolutely required under Florida law.
Okay. Which one do you want to take up next?
I'll defer to defense.
Judge, if we could call up the motion to suppress the wiretap evidence.
Okay. Okay. Okay, thank you. Okay, I'm ready.
Yes, Judge, and as a starting point, I don't think there is any dispute on the law between the state and the defense here. And as I heard this court state this morning in Mr. Tennant's case, oftentimes motions turn on the facts. And so I'm going to focus more on the facts and the law. I believe the court knows that essentially it's supposed to give deference to the magistrate or the judge in this case that signed the warrant. But we do ask the court to conduct the appropriate review of the wiretap warrants that were provided to the court. I've also provided a disc to the clerk, Your Honor, with the same documents that were provided to the court. Your Honor, the wiretap evidence should be suppressed because the intercept orders were not supported by particularized probable cause. The state's presentation was voluminous. It's a very long document, but volume does not equal probable cause. The application and the affidavit repeatedly grouped Ms. Gardner together with other target subjects, but the facts actually alleged against each person are materially different. And this court must evaluate the probable cause for Ms. Gardner separate and distinct from the other targets. The affidavit contained direct evidence tying Mr. Tennant to the murder scene, the suspect truck, and the tire. It articulated evidence tying Mr. Fernandez to Tennant, Ordway, and Biggerstaff and the rental property. And it articulated communication or movements between those individuals, those four individuals, not Ms. Gardner. The allegations in the affidavit made against Ms. Gardner were largely motive, family court history, post-defense media reaction, and her marriage to Mr. Fernandez. That is not enough, Your Honor, and it should not have been enough for the reviewing court if the reviewing court had actually looked at the affidavit and analyzed it as they were required to do under the law. Because what we're talking about here are real-time interceptions of private communications of a United States citizen. The January application expressly identified the 5 target subjects. Those were Tennant, Ordway, Biggerstaff, Fernandez, and Ms. Gardner. I'm sorry, Tennant was in jail at that time. But in collective terms, held that they had motive and opportunity, confirmed relationships, communication patterns, and evidence of the conspiracy. So he used generalized terms and then sought to intercept the phones of Fernandez, Gardner, Biggerstaff, and Ordway after law enforcement was to publicize Tennant's arrest in order to trigger communications among the targets. So that's the framework that the police and the state have orchestrated with the hopes that they would get a warrant to record all of these individuals' phone calls. But here's the problem. Biggerstaff was described as Fernandez's longtime associate, having frequent contact with him before, during, and after the homicide, and having lied about a potentially relevant firearm that may have been used in the murder. Ordway was described as Tennant's roommate who had been Fernandez's tenant, and someone believed, I'm talking about Ordway, someone believed to have had a role based on witness statements and phone records. Ms. Gardner, however, was described simply as Bridegan's ex-wife, Fernandez's spouse, and that she lived in her house where the children were dropped off that night. The affidavit sets out evidence that the homicide was a planned ambush, that Tennant's truck and tire were connected to the scene, that Fernandez was the single link between Tennant and Bridegan. It then asserts that Fernandez enlisted Tennant, Ordway, and Biggerstaff to assist in the murder. And the only link is that Ms. Gardner, quote, provided monetary compensation to Fernandez, which he then used to compensate Tennant. Now, besides the fact that monetary compensation to Fernandez is simply false, and this court knows that from prior evidentiary hearings, that there's no evidence that Gardner provided any monetary compensation to Fernandez, which he then used to compensate Tennant. But the factual basis for the affidavit's leap to connect Ms. Gardner is thin. It's simply motive. It's not a communication. It's not any direction. There's no evidence of any actual payment by Ms. Gardner or any specific transfer of money or funds. There's no surveillance that observed anything involving Miss Gardner. There's no cell site location records implicating her, and there's zero statements by anyone connecting her to the alleged murder for hire arrangement. The state's strongest facts against Miss Gardner were simply motive facts. The assertions, the motive, is not the same as probable cause. Because even the state's case law that I believe they're going to give the court, you have to have facts. You have to articulate specific facts that connect someone to a crime. And they simply didn't do it. Many people have contentious divorces. Many parents have custody disputes. Many people consult lawyers, public relations professionals, friends, and family after being publicly associated with a homicide investigation. And the United States Constitution in Chapter 934, they require more before the state can listen to private communications in real time. There's nothing that particularizes probable cause against Miss Gardner, and there's nothing that shows she knew about the tire, the truck, the firearm, the plan, or any payment to Mr. Tennant. The application's trigger action section further exposes the weakness in the probable cause, showing that the reviewing court should have picked up on if they had not abandoned their role. The state did not claim that Miss Gardner had made incriminating calls before with anyone, or that there was a real probability that she would make them if this trigger thing happened. So it was not a, hey, we know she discusses the murder on the phone with other people. Instead, it planned to create a media event and then listen to her reaction. And so it relies on this leak to the media that there had been a break or an update, and then announcing Tennant's arrest. And that may have been an investigative tactic, but it cannot support probable cause retroactively. It had to exist before the interception began, and a plan to provoke conversations about a highly publicized murder investigation does not prove that Miss Gardner was likely, or that they had probable cause to establish that she was criminally involved. There's also issues with the February application, Your Honor. That's an application where the state obtained a wiretap for Miss Gardner's sister's phone, SH, believing that based on an intercepted phone call, Miss Gardner would seek to use her sister's phone when her sister was visiting her. Your Honor, there's not probable cause to believe that any conversations using the sister phone would actually have supported, would actually have occurred that would have discussed the murder, or that there was probable cause at that point that Miss Gardner, again, was involved. In the February application, they rely on actual intercepted statements. You'll see that. But if you actually read or look at how they describe Miss Gardner's calls with Miss Jensen, they're discussing media coverage, public relations advice, alternative theories, some concerns that Mr. Tennant might implicate her, and a concern that law enforcement may interpret some seed money that Mr. Fernandez gave to Mr. Tennant as a payment. Those are not admissions. Those are consistent with a person who knows she's a suspect, is receiving legal advice, and is worried about media pressure. There's simply no connection, no nexus that is necessary between the crime here and recording Miss Gardner's phone calls. either in the January application or the February application. The warrants rested on guilt by association and investigative hope. And Your Honor, that is not simply enough to wiretap someone's phone. I know we don't like to say that the standard of probable cause is different depending on what type of warrant the state is seeking, but there is a whole section in the Florida statutes dedicated to wiretapping for the very reason that it requires heightened scrutiny. And the reviewing court did not sufficiently read this affidavit and the application with respect to Ms. Gardner and simply rubber stamped it. There was not probable cause here, and the wiretaps were unlawful, Your Honor. And for that reason, this court should suppress the wiretap evidence of Ms. Gardner's phone and her sister's phone.
Thank you. Hear from the state.
Yes, Your Honor. I provided a case to Mr. Carodi, which I'll provide to the court as well. United States versus Ventresca, Ventresca, 380 U.S. 102. It's a United States Supreme Court case from 1965. And what it discusses is the deference given to a magistrate's determination on a search warrant. And the court goes through the historical overview of the purpose behind a search warrant for the Fourth Amendment purposes, and that the case law and the review by those looking at a magistrate's determination is given great deference because the courts historically have accorded great preference to police action taken under warrant, which is subject to judicial review, rather than search and seizures without one. They discuss that probable cause is less evidence than would justify condemnation. So while Mr. Carodi argues the evidence, in his mind, probable cause is a low bar. In his mind, it may not rise to the level of a higher standard of proof, but certainly the courts have well established that probable cause is a flexible, it is a rational and common sense approach to looking at evidence. It is merely reasonable grounds that evidence of a particular crime will be found in a particular place. In this case, the court writes that the recognition that the Fourth Amendment's commands, like all constitutional requirements, are practical and not abstract. That's at page 746. Affidavits tested and interpreted by magistrates and courts must be done in a common sense and realistic fashion. These affidavits and warrants are drafted by non-lawyers in the midst and haste of a criminal investigation. Technical requirements of elaborate specificity, once exacted under common law pleadings, have no place in this arena. And they discourage the court from taking a grudging or negative attitude towards warrants, because that would discourage police officers from submitting them and having that judicial review. The court writes that the resolution of doubtful or marginal cases should be determined by the preference to be accorded to warrants. I say this to the court to say, in no way do I believe that this is a questionable or marginal determination before the court. I believe that the affiant, in this case, outlined with specificity and at length the bulk of the evidence in relation to a conspiracy between multiple individuals and to Ms. Gardner's participant as a principal to the murder of Jared Bridegan. The cases cited by Mr. Carodi in his motion generally support the fact that courts are begrudging to suppress or exclude evidence where a magistrate has reviewed it and where there has been specific and articulable facts outlined by the affiant. The test, he cited Cherney versus State in his motion, 348 Southern 2nd, 395. That is a third DCA case. The court in there, and he cited it for the proposition that probable cause cannot be based on mere suspicion. That the court in so holding goes further and says that the test for whether an affidavit establishes probable cause is not whether the evidence is admissible or sufficient to prove guilt at trial, but whether that information would lead a person of prudence and caution to believe an offense has been committed. And that test depends on the probabilities determined by factual and practical considerations of everyday life on which reasonably prudent, cautious persons, not legal technicians, act. In the case he cited, the court found that there was sufficient facts outlined in the affidavit, that reasonable inferences could be made from those facts, and that an inference is the essence of probable cause. What we're talking about here is a perfectly acceptable way to prove a case beyond a reasonable doubt or by probable cause or otherwise, which is the law recognizes circumstantial evidence as well as direct evidence. The affidavit is replete with both as it relates to Ms. Gardner. There is a discussion of direct evidence that would suffice for probable cause in her involvement. She is one of the co-owners. She was the one who applied for a limited liability corporation license for First Choice Home Rentals, which is the account on which the payments to Mr. Tenen were drawn. There is evidence in here that she financially contributed initially to First Choice Home Rentals through payments from her trust fund, the Shanna Gardner Irrevocable Trust Fund. So there is a nexus between her finances and the payments that ended up in the hands of Henry Tenen. There is evidence in here from direct statements from Ms. Gardner herself to members of the deceased victim's family that she was, and I'm paraphrasing because I don't have the page in front of me, but that she was looking for someone to take care of him, to get rid of him. She told a friend on page 7 of the affidavit, she advised a friend that she and Mr. Fernandez had a discussion, that Mr. Fernandez told her he could take care of him and no one would ever know, referring to the deceased victim. That Mr. Fernandez told her, and she's telling this to a friend directly, that he could, quote, get 4 guys, break into Bridegan's residence in the middle of the night and take care of him. So there is direct evidence from her own statements to individuals that are outlined in this affidavit that she had the conscious intent voiced on her desire or hope to take him out, get rid of him, take care of him, hire a hitman, etc., and that she had had those conversations as disclosed to a friend with Mr. Fernandez. And Mr. Fernandez, throughout this affidavit, has direct connections to Henry Tenen, who is more than enough evidence to suggest and to prove that he was the shooter in this case. Video evidence, Google location evidence, cell site location evidence, DNA, his possession of the vehicle. The court looked at evidence as outlined in the affidavit of her phone discussions or her phone calls during significant times in the investigation with significant members of this conspiracy. Specifically, when Mr. Fernandez was asked to come give his interview to the Jacksonville Beach Police Department on February 28th of 2022, it was scheduled for the next day, March 1st, 2022. He deleted over 5,400 items from his Google account. He went to the interview. Ms. Gardner went to the interview. It outlines their statements to police, which outline their dislike for the victim. Mr. Fernandez's comments to police that the kids would, quote, be better off without him in the picture, that they were fighting for majority custody, that he and Mr. Bridegan had some sort of confrontations, altercations, or disagreements in the past about child care issues and drop-offs. And then we see in the affidavit outlined, at the time known to the affiant, that she is calling Mr. Fernandez while in between the time that he had his interview, their children are scheduled, or rather his stepchildren, her children, are scheduled for a CPT interview regarding the whereabouts of all parties and the deceased victim the night of the homicide, that she is repeatedly speaking to Mr. Fernandez as he takes what Your Honor has heard in testimony before in other hearings, but is outlined here, an unplanned, spontaneous trip up the coast. There's evidence that Ms. Gardner had phone contact with Mr. Fernandez and with her criminal defense attorney and her public relations firm on August 18th of 2022 when Mr. Tenen was arrested on unrelated charges, unrelated to the homicide. So there is direct evidence of her communication with co-conspirators. There is evidence of her having direct control and or access to funds that were used to pay Henry Tenen. Just because there are innocent explanations for individual pieces of evidence, the law says that the court is to look at probable cause under a totality of circumstances. Just because you remove one fact and can give an innocent explanation to it does not mean that that innocent explanation should or can or shall be accepted. The court can still consider other purposes for that evidence and consider it in the totality. In fact, the courts caution against doing that. They want the courts They want the magistrate to look at this in a totality, to look at it with a common sense viewpoint, to look at it at what is known to the affiant at the time and what the affiant's reasonable assertions and conclusions from objective evidence can be relied upon. Detective Johns in this affidavit did not merely say Ms. Gardner has significant contact with her co-conspirators, she contributed financially, she has a motive, case closed. He gave his opinion, and he also gave the magistrate the objective data and facts outlined at length. So the magistrate was free to accept or reject his assertions based on his training and experience and the knowledge that he received from other agents and other officers in this case, as well as statements he received from witnesses in this case. Mr. Carote's cases he cite, for the most part, the court has upheld denial of defendant's motions to suppress. Further, in the cases he cited in his motion, discuss the exception, or the Leon exception for good faith. I know and I understand that the defense is limited in what they can argue to exclude the entirety of the wiretap because of this exception. And if a magistrate issues a valid search warrant that appears to have probable cause on its face, the Supreme Court and the progeny of Leon has said an officer, the point of suppression is to deter bad police conduct, not bad magistrate conduct, bad police conduct. So for your honor to grant the relief Mr. Carote is asking for, you would have to find that this 51-page application and 18-page order that outlines these direct and circumstantial pieces of evidence that draws upon reasonable inferences the affiant made from objective evidence that he provides to the magistrate is so devoid of probable cause that any officer reviewing a validly signed warrant by Judge Meredith Carbula with the 4th District or 4th Circuit here would be unreasonable in doing so, and that's just not the case here. And the defense has failed to meet its burden in showing that to the court. And I just will further cite that in all of these cases that he has cited in his motion involving guilt by association, those are very distinct and discrete on their facts. Those are talking about cases where a car is pulled over and a search is done of the vehicle absent a warrant, or a search warrant of a house where a husband or a wife or an individual is merely present at the time a search is conducted for something tangible like narcotics. And they're trying to infer that because so-and-so is in the vehicle with so-and-so who has narcotics, that therefore we're going to search them and we're going to arrest them for guilt by association on these joint constructive possession issues. This is a very specific case, and the probable cause and factual determinations in this affidavit are very fact-specific to a conspiracy, to a long-term plan for a murder for hire, to a cover-up of a homicide, to continued conversations between the co-conspirators. And based on what is outlined in here, the judge was extremely reasonable in finding probable cause, and the officers were even more reasonable for relying upon that in executing the search warrant and intercepting those wiretap communications. So we're asking that the court follow the case law, follow the United States Supreme Court in Ventresca and Leon and its progeny, and deny the defense motion.
Okay. Mr. Carote, I'll give you the last word.
Yeah, just briefly. So I would ask the court to read the application, the affidavit. I do have some disagreement with Ms. Stifler's recitation of what was included in there, but the court has the document and is limited to 4 corners. The deference that this is a non-lawyer document, Your Honor, I think is not the case here. I'm pretty confident that either a state attorney wrote this or at least edited it before it went forward to the court. So this is not the type of affidavit that deserves deference that law enforcement's writing in the middle of the night. This is obviously a document that had legal work performed on it. And then the only other thing I want to point out is that the whole purpose of a trust, as any lawyer knows, Your Honor, means that you can't control the money. So a judge should have known the fact that Ms. Gardner was the beneficiary of a trust means that she doesn't control the trust money. I mean, that is 101 legal. And so
you're arguing that to say what? That the magistrate was...
I mean, the state has tried over and over again to connect Ms. Gardner to money. But all they say is that there was the Shanna Gardner Trust. Well, it's in the document. Mr. Fernandez was the trustee Ms. Gardner was the beneficiary. A trust means that the trustee controls the money
Right.
for the benefit of the beneficiary. But
So
the
you-
beneficiary can't force the trustee to do anything unless you go to court and you sue someone for a fiduciary duty violation. But
Okay, so you're arguing that fact to say that when reviewing,
right, when a judge is reviewing this, a judge should be like, well, what does it matter that there's a trust that she benefits from? That's not her financially. Ms. Gardner cannot financially compensate anyone through her trust. She, as a beneficiary, she has no control over the trust. And that's the point, that there's no financial connection. That Ms. Gardner was on an account that was used to write checks to Henry Tenen that were signed by Mr. Fernandez.
so you're saying a judge should have known that, so that fact should fall away. That couldn't lead to probable cause within the four corners. Is that what you're saying?
That seems to be, as the state goes through here and makes arguments, again, I agree the case law is the reviewing judge deserves deference. But I heard the state talk about that was one of the things that a judge could have viewed or would have seen and would have agreed that it clearly established probable cause. It shouldn't. Just like the fact that Ms. Gardner had communications with her husband.
Okay,
Thank you, Your Honor.
thank you.
Good afternoon, Your Honor.
Good
Kirsten
afternoon.
Nelson. I would like to take up Ms. Gardner's remaining motion to suppress, which relates to 3 warrants, one for her iCloud account, her Google account, and her iPhone. I'm going to focus primarily on the iCloud account since all 3 warrants have similar problems. I'm happy to answer any questions about the other 2.
Okay,
Your Honor, what we have here is that the state sought and was granted 3 separate warrants that essentially gave law enforcement unfettered access to Ms. Gardner's life. Every email, every photograph, every internet search, and every deleted file. And then law enforcement was allowed to rummage through those files with unfettered access to determine what they thought was relevant. To paraphrase Justice Brandeis, the progress of science does not erode the Fourth Amendment protections. And so what we are asking this court to do is to examine these warrants and to uphold what the Florida Constitution and the federal Constitution require. And that is suppression of this evidence. Mr. Carodi has already talked to the court at length about probable cause, but we're again talking about probable cause here. I won't repeat all of the same arguments Mr. Carodi made. We would incorporate them by reference. However, there are some that are particularly pertinent here. The first is, when we're looking at warrants, as this court knows, there are 2 requirements under probable cause. The first is the commission element, and the second is the nexus element. And so I'm going to take them one at a time. So when we're talking about the commission element, meaning, is there probable cause to believe that Shanna Gardner committed the exact crime for which the magistrate found probable cause? So if we're looking at the iCloud warrant, which we submitted to the court, and I'm happy to provide additional copies if helpful, the commission element there is only premeditated murder. That is the only crime for which we are talking about probable cause, not conspiracy, not child abuse, not murder for hire. And that's important because the facts are slightly different. So what we see here, Your Honor, is that we do not have evidence, allegations, of Ms. Gardner's involvement at all pre-Mr. Bridegan's death. There's nothing in the warrant to suggest that Ms. Gardner was involved whatsoever pre-death. Not only that, the evidence that is cited regarding Ms. Gardner's involvement is more along the lines of conspiracy. But there wasn't a finding of probable cause for conspiracy. So that cannot provide the basis for a valid search warrant here. When we strip away all of the, I'll say, conspiracy-style allegations about relationships and communications with co-conspirators and things of that nature, what we are left with is very similar to an argument that Mr. Carodi made earlier, and that is that the affidavit focuses on Ms. Gardner's intimate relationships. Mr. Bridegan was her ex-husband, and Mr. Fernandez at the time was her current husband. But Your Honor, that's nothing more than a hunch dressed up in a marriage certificate. And the Supreme Court has been very clear, a hunch is still a hunch, and that is insufficient for a finding of probable cause. I would direct the court, and we cited this in our motion regarding intimate relationships and casual associations being insufficient for probable cause, to U.S. v. DeRee, D-E space R-I, that's at 332 U.S. 581. Unless the court has questions regarding that argument, I'll move on to nexus.
You can.
Thank you, Your Honor. When we talk about nexus, the reason that this is important is because we're talking about warrants that, under the affiant's own admission at a previous hearing, give them massive amounts of information, very intimate information. Detective John said that in Ms. Gardner's bond hearing, and he was right. And so it's not, the Constitution does not allow law enforcement to get all of this data that far exceeds anything related to a crime unless they can show that that specific place to be searched has a connection to the very crime for which they claim that there's probable cause. So what does that mean here? We're talking about the iCloud account and premeditated murder. So what is the relationship between the two? And when we look at the affidavit, there is no substantial evidence that a search of Ms. Gardner's phone ending in 4571 or the iCloud account associated with that phone number would produce evidence of premeditated murder. And that phone number is important, Your Honor, and I'll circle back to that in a moment. But the reason that we see that there is no nexus here is because this affidavit, as lengthy as it is, it doesn't even say that Ms. Gardner had an iCloud account. At base, that should mean that there is no nexus and therefore no probable cause and that this warrant can't stand. But even setting that aside for a moment, the only allegation regarding Ms. Gardner and an iCloud account where the police actually say, we know that Ms. Gardner has an Apple product, is about an iWatch, or an Apple Watch, excuse me, Your Honor. And in fact, that Apple Watch isn't even associated with the phone number for which they requested this warrant, the number ending in 4571. And there are no further allegations that connect Ms. Gardner's use of any Apple products to any other allegations that could be connected to a premeditated murder. And we cite cases regarding this in our papers, Your Honor, but just to remind the court, general propositions and allegations based on training and experience cannot bridge the gap between lacking factual allegations and a finding of probable cause. As Ms. Stifler said earlier, the only thing that they can do is provide context for facts that are actually alleged. We don't have those facts here in order to bridge that gap. The case I would cite for that, Your Honor, is U.S. v. Martin, 297 F. 3rd, 1308. That's the 11th Circuit, 2002. The second requirement, Your Honor, relates to particularity. So we believe that these warrants fail to state probable cause. That means that they should be suppressed. But even if the court finds that there is probable cause, they still fail particularity, which is an independent basis for the court to suppress all three warrants. First, I would start with the date restriction issues. These warrants are slightly different in the scope that they seek. However, I do think that United States versus McCall, MCCALL, it's an 11th Circuit case, 84 F 4th 1317 from 2023, is important for this court to take a look at. And the reason is we have a very similar warrant in McCall. Where what we have there, what we had there and what we have here is a two-step warrant, where the police go to the court, just as they did here, and they seek the entirety of somebody's account, which is exactly what happened here. And the judge signed off on it. And then there's a second step in the warrant, just as there is here, that says, now we're going to comb through this information and we decide what's relevant. In McCall, the 11th Circuit said, well, actually the district court and the 11th Circuit agreed that that was overbroad. That was too much. They assumed, without deciding, that it also lacked probable cause for the very same reason, because it was so broad, there's no way that all of those categories of information could be supported by probable cause. Where I disagree with the 11th Circuit is that they found a good faith exception. I think we're standing in a different posture, especially a couple years after McCall, and there are several Florida cases that I think eviscerate the good faith exception here. But that's important because the 11th Circuit was very clear, and other circuits have been clear as well, that under the Fourth Amendment, when you have a warrant without any date restrictions, that alone warrants suppression. That's what we have here. And the warrants that do have date restrictions, those date restrictions are not tethered to anything meaningful, meaning they're arbitrary. They're not supported by probable cause. They are not particularized to the facts in these affidavits. I would also point the court to United States versus Blake on this same point. It's another 11th Circuit case from 2017, where the 11th Circuit specifically pointed out that when we are talking about these cloud-based accounts, which is what we're discussing here, law enforcement has the ability to target, to limit, both by date and subject matter. That is oftentimes an argument that we hear in these cases, well, we have to take everything because that's just how it comes. And the 11th Circuit said that's not true. They said it in 2017, and they said it again in McCall, and just as it was true then, it is true here today. Law enforcement has the ability to narrow these searches so they are not collecting every piece of somebody's digital life and then allowed to sort through it. That's what we're asking this court to do here. Regarding subject matter restrictions, it's a similar argument, Your Honor. I would point the court to State v. Demons, D-E-M-O-N-S, which is a Broward County case. I believe that Ms. Stifler provided the court with all of the applicable filings. We cited it in our papers. That case is incredibly similar. And the reason that I pointed out specifically to the court is because there were many online accounts in Demons. And the judge specifically found that, number one, law enforcement had the ability to do this limit that we're talking about in step one. So before they get everything from Apple or Google, they could have narrowed, but they didn't. And then, in addition, the failure to limit by relevant times or descriptive terms makes these warrants overbroad, just as it did in Demons. So it's a two-step problem. It could have been done in step one, and then failure to do it in step two with any sort of meaningful guardrails, which is what we have here as well, also is a problem under particularity. The final case that I would point the court to, and I'm happy to hand up a copy because I understand Ms. Stifler had some difficulty finding it, is in-ray search warrant application received March 13th, 2023. And this is a bit unusual, Your Honor, but this is a magistrate judge from Miami-Dade County who received one of these two-step warrants, again for a cloud-based account, just like we have in this case. And that magistrate judge denied it and decided to write an opinion on this and publish it because he said, to paraphrase, "We see this problem too much. This violates both the Florida and federal constitution. And so I am issuing this opinion as guidance to those who come to the court and seek a search warrant." We have the same issues here, Your Honor. So unless the court has further questions, I'm happy to.
You have a copy of that?
Yes, I do, Your Honor.
Okay, could I have it? Thank you. Ms. Stifler?
The state rely on arguments I made previously in regards to the wiretap, incorporate those into arguments regarding the probable cause as to the affidavits in these search warrants. I will also note for the court, these search warrants are not only focused around the idea that evidence of the homicide itself will be found in these devices. And just for reference, the iCloud does reference the statute numbers for first-degree premeditated murder and child abuse. The Google search warrant does reference these statutes for first-degree premeditated murder and child abuse. And the affidavit and search warrant for the iPhone does reference statutes for murder, conspiracy to commit murder, accessory after the fact, and child abuse. Although there is the charges as outlined are under investigation and the charges eventually charged are not relevant to the court's determination of probable cause. By its essence, a premeditated murder involves discussions prior to the homicide, a conscious intent to effectuate the homicide, and therefore would encompass a larger range of time period for a probable cause search, regardless of what type of evidence. Inherently in its nature, particularly when we've outlined there are multiple individuals involved in the planning of the homicide. There's no statute for murder for hire. So that should not be a factor for the court that there was some failure of articulation of probable cause or a finding by the magistrate for a murder for hire. That is not a Florida statute. It's sufficiently enveloped in the premeditated murder statute and the probable cause outline as to multiple individuals, principal theory, and conspiracy, as stated in the iPhone. I am going to talk about the particularity requirements for digital evidence. I do have a witness to take testimony before the court. At the end of Ms. Nelson's motion, she brought up a Franks violation that the affiant did not include a paragraph, I guess rather a Johnson, it's an omission, that the affiant did not include a paragraph in any of these warrants or affidavits stating that Google and Apple have the ability to, what I'm called, selectively characterize evidence either by subject matter or time frame.
Did you let counsel know that you had a witness? I wouldn't have.
Yes, I let
Okay. And that's how y'all wanted to proceed? I didn't want,
I can either argue first or take testimony from the witness first.
what do y'all prefer?
We'll take testimony. He's a CFIU detective. The state's not offering him as an opinion witness in any way. He's here merely to give context and define some of the terms in the affidavit and discuss Google and Apple policy in general as it relates to the Franks allegation of selective categorization.
Okay, is he already here?
Yes, ma'am. Detective J.S. Padilla.
So we've been going for about an hour. I'll take its testimony and then I'll take like a 5-minute break, okay? Good afternoon.
Detective, you solemnly swear or affirm the testimony you give will be the truth, the whole truth, and nothing but the truth, so help you God. I do.
Great. You may proceed.
Good afternoon, Detective. Could you please state your name for the record?
Detective James Padilla, P-A-D-I-L-L-A.
Hold on just a moment. We were testing. You can get the body mic. We're trying something new. You can, we turn that microphone off, if you'll push that back.
Where do you work?
The Jacksonville Sheriff's Office.
And what is your role with the Jacksonville Sheriff's Office?
I'm a digital forensic examiner in the Computer Investigations Unit.
And Detective Padilla, are you also a member of the United States Secret Service cross-sworn agent?
Yeah, I'm a task force officer assigned to the Secret Service.
And briefly before we begin, although I'm not offering you as an expert, would you mind giving the court a brief outline of your background in terms of your education and training and experience as it relates to computer and device forensics?
Yes, I have a master's in science for digital forensics out of the University of Central Florida. I have certifications in both mobile and computer forensics from the International Association of Computer Investigative Specialists, or IASIS for short. I have certifications from Cellebrite in both their products and some of their Cellebrite mobile forensics. I have trainings for both mobile and a variety of other disciplines from the National Computer Forensic Institute by the Secret Service, as well as a variety of trainings for both mobile computers and other digital forensics needs from the Federal Law Enforcement Training Center out of Brunswick.
And how long have you been with the computer forensic unit at the Jacksonville Sheriff's Office and/or Secret Service?
Since November 2016 for digital forensics, and I've been, I think, 2018 for Secret Service.
And in your career, have you had the opportunity to perform forensic extractions of digital devices, including iPhones?
Yes, I've done over 1,200 exams on cell phones.
And in your career, have you had the opportunity to receive, either seek through a warrant or consent and receive and review returns from third-party providers for digital evidence, including Apple
I have,
and Google?
yes.
I want to talk to you today. First of all, you've had some involvement in this case in testified before this court before in regards to some hash values of digital evidence, but you yourself are not an investigator in this case, correct?
Correct.
So you have nothing to offer today in terms of any factual allegations regarding this case?
Not at this time.
Okay. What I want to ask you about is something defense counsel wrote in their motion regarding the ability to do what's called selective categorization or partial extractions of digital data. You know what I'm referring to?
I do.
Have you had an opportunity to review Ms. Nelson's motion?
I have.
And have you had an opportunity to review the 3 search warrants at issue in this case for an Apple iPhone, a Google return, and an iCloud?
I have not reviewed the warrants.
Would it be helpful to you to have copies of them as you testify today? I'm going to ask you to define some terms.
Yes.
May I approach?
Yes. Did you show, okay.
And these were attachments by defense counsel to their motion. Detective Pedia, can you describe very briefly for the court the policies and procedures of JSO in terms of receiving digital evidence from an iPhone?
Yeah, so the workflow is a detective will seize an item, bring it to our office. They will put in a request for examination, along with any legal justification, either a search warrant, written consent, or implied consent are the only 3 that we accept. In the case of a search warrant, we'll review it for legal justification to see if there's any scope limitations. We'll validate that the device is listed as the device that we received, and from there we will continue with a method of extraction based on those information.
When you receive a phone that you're doing an extraction of pursuant to a search warrant, you also receive a copy of the search warrant.
That is correct.
And do you generally review the contents of the search warrant to see that it looks sound and based on your training and experience to conduct the search or extraction of a device?
Objection, relevance. He said that he didn't review the search warrants in this case. He can't speak generally to what the practice
What's
is.
the relevance of that?
Well, I'm asking him about how it.
What JSO does, what difference does that make?
I can move on.
Okay.
When you perform an extraction of a phone or a device, can you explain to the court the types of extractions you can perform?
Yeah, the highest level is a physical extraction. This is a bit-for-bit copy of the memory space of the device. Below that would be a full file system extraction, which is the closest thing we can get to a file system. It's basically copying the entire contents of the phone over to another device. A lesser file system extraction would be the next level down, and it's not quite as comprehensive, but it's essentially the same thing. Below that would be a logical extraction, which is where we would be the first opportunity for us to do any kind of selective categorizations. This is basically an API call or an application programming interface, and it basically tells the phone, hey, I'd like to see the messages, please provide me the messages, and it responds to that way. And below that would be a manual examination.
And what is a manual examination entail?
Visually looking through the device.
Are the ability to extract different levels, does that depend on the age of the phone, the presence of whether or not you have a password?
Yes and no. A lot of it has to do with that. Also, is the type of device, the operating system version that's running, and the capability and research that the software that we use, its capabilities.
When you receive a search warrant to do a cell phone extraction, unless otherwise specified, do you attempt to extract at the highest level, meaning a physical extraction?
Yes.
And in your experience, do you have the ability in the extraction process itself to put temporal or subject matter restrictions on the data as you're extracting it?
Limited, yes.
Based on your experience with the computer forensics unit, is it practical to do a partial download if you have the ability to do a full physical extraction?
It is not.
Objection, relevance. The question is not what's practical, the question is whether there was an omission to the ability to do that partial extraction.
Stifler?
Your Honor, they've made an allegation that if the magistrate had known that there's the ability to do subject matter categorization of these devices and clouds, that the magistrate would have therefore not allowed the warrant to proceed. Therefore, the court, I want to have an understanding of the practical and real-world application of doing these searches, because the analysis by the court, as the courts have said, should be a realistic and common sense approach to how these searches are conducted by officers in the field.
If I may briefly respond, Your Honor.
Yes.
So I want us to take a step back. What we said was that there was a Franks violation as to the iCloud warrant. What the officer, or the detective, excuse me, is testifying to is the ability to physically extract an iPhone. These are two different things. I haven't heard anything about the officer's ability to extract an iCloud account, which then perhaps there would be some relevance to this testimony.
Maybe I'm misunderstanding both of you. Okay, so I understood the defense to say that the information in the warrant should have been suppressed because it was overbroad in and of itself, and that this should be curtailing from the warrant stage on. Am I understanding that correct?
That's correct, Your Honor.
And then this, and then what I'm hearing the state to say is that even on the front end, at a global download sense, that there is the mechanism to then curtail it at the, I guess, the investigative level, even though that there might have been more information given by the magistrate.
I'm asking the witness if that's true. They have to establish that what they're saying is an omission is true. I say, is there the ability to do this? He says, yes, with limitations. It's unfair that he's not allowed to then discuss the practical limitations of what they're suggesting should have been done in this case. If we're talking about an overbreadth of search, too many categories should not have done a full phone download. I want the witness to give context to.
A cloud at this point.
I'm going to ask them about the cloud as well. They made the overbreadth argument as to all three: the cloud, the Google return, and the iPhone, saying there should have been subject matter restrictions and date limitations on all three.
Your Honor,
I thought it was from the warrant state. I don't know.
allow me to clarify
Okay.
what our argument is. So we have a suppression argument that I agree with the court's characterization earlier. We also have a separate argument as to what we believe was a material omission from the warrant affidavit in support of the iCloud. And so my objection here is that the detective is testifying about the ability to extract a device that we're not saying there was a material omission about. So
Okay.
I'm
All right, so I'll sustain the objection if you'll move. If that's your purpose, then move to what they're saying the omission is.
They also said that we should have put a time scope limitation on the iPhone because the affidavit says they're seeking communications between parties. I intend to ask this witness about where communications are found in phones and whether you are able to use a time restriction and uncover communications in a phone. I think that directly rebuts or allows the state to have testimony rather than just argument as to the practicality of what they're suggesting and why it's not overbroad. Why does the state seek a larger breadth of time and categories in a phone download than they would otherwise if they're looking for communications? The witness can advise the court where communications are stored in a phone. It's So the state then can argue why it was proper we sought all these categories and without a time restriction.
Give me a second.
The defense has cited the Damon's case. This is the analysis the trial court took in that case as well. I do have questions for the witness about Apple and Google as well.
Give me 2 seconds. So I went back and read it. So where I think the argument about Damon's appears to be on your page 11 in your papers, okay? I was understanding that to mean when the limited search was the request to the search. Am I misunderstanding that? Like that the detective could have requested a certain time frame and limited from the magistrate's perspective what was authorized to be given from whatever provider. I didn't understand that to mean on an investigative level that somehow that could be parsed out after there is, if I'm hearing the defense, an overbreath of the warrant. Am I misunderstanding that? I think what the state is asking is on an investigative level, they could have gotten everything, and then on a searching level, they could have said, no, we're not gonna look at this, or we're not gonna produce this. Am I misunderstanding that? Because he said, we get the warrant at JSO, which I sustain the objection, but we get the warrant from JSO, I look at the warrant, I make sure it's the same device or whatever was authorized by the court, then I can do these different levels of extraction. That's on an investigative level, and I thought the defense was complaining on a broader search warrant level.
It all relates. Their argument is fourfold. We don't have PC.
Where is that argument? That's what I'm,
The argument is they're citing the Damon's case, and they're citing specific rulings by the trial court, not the appellate court that reviewed it, which ultimately denied the motion to suppress and upheld the trial court's ruling that limited to a time or date certain digital evidence. There was 13 search warrant in Damon's, however you want to say it.
Okay.
Provided the ones that issued to the court.
okay.
One of them involved the search of a cell phone, as in here, and they're citing it for the proposition that the warrant in Damon's for an iPhone had a time restriction on it. They are saying that our warrant was overbroad because it did not have a time or a category restriction on an iPhone.
Okay,
The warrant is the subject matter being sought. The evidence being sought per the warrant in the affidavit is communications. In order for the state to argue to the court why it's not overbroad, that we didn't have a time limit, we didn't have category devices, it's proper for me to ask a detective with CFIU who has experience where communications are stored in a phone. If communications are stored only in native messages, then they have an argument we should have only sought native messages. However, that's not how phones work. That's not how criminals hide criminal activity. That's not how communications work nowadays. Instead of me arguing this, the state wants to present the evidence of a detective. And part of their argument is we're not entitled to the good faith exception here because no reasonable officer executing a search would have relied upon this warrant. So the fact that Detective Padilla spends all day, every day, relying on warrants such as these to perform the searches, which is the extraction, I think his testimony is relevant to the court's consideration as to the breadth of the affiant's search warrant, the return from the phone. They're asking, although they haven't specified specific evidence from a phone, they're asking to suppress the entirety of a phone.
All right, so I went back to what the question was and what the objection was, which the question was, based on your experience with computer forensic unit, is it practical to do a partial download if you have the ability to do a full physical extraction? Answer, it is not. Then the objection came to the relevance of this to this particular motion. All right, and then so you're saying that he needs to be able to explain what is practical if they have the ability to have everything. Like, what does that have to do with my decision? What's practical in his view, in his opinion, that you said you weren't offering?
Practical is a starting word for further questioning as to why isn't it practical? Because you're not going to get the full data and you're going to miss databases with communications in them. I can ask it more directly, but I'm trying to lay a record for the court. A factual record from a witness who has knowledge as to the context of these devices, how data is stored, where it's stored, so that the state can make a proper argument why these items shouldn't be suppressed and why it's not overbroad to look into all these areas for the evidence that we are seeking. Give the court insight and context as to, if you have a house, you're looking for a gun in a drawer, that's one thing, but if you're looking for a communication in a cell phone, it could be maintained in a variety of places. This witness is here to give the court context as to the manner of places it could be stored and whether or not it has metadata, if it's been deleted or stored in another manner.
Okay.
That goes directly to their argument, unless they're abandoning it and only want to proceed on the iCloud, that the phone search was overbroad as to time and date and subject matter.
All right, Ms. Nelson, so before I rule, I want to make sure, you can lay whatever record that you want. This is a hearing, so I'm not being so strict about it. But I don't want to waste time with information that you don't believe that you're arguing, so.
Sure, Your Honor. Perhaps it would be helpful if I clarify.
Okay.
So,
Am I on the right page of what you're saying? It's like 9 through 11 is where I'm finding what you're objecting to, and the state's saying you're doing more. So is it someplace else that I'm not seeing?
no, Your Honor. So my objection is that we started this hearing, the court allowed the defense to orally argue its motion. Then the state started arguing regarding suppression. At the end of its suppression argument, then Ms. Stifler raised that we made a Frank's argument, which is separate and apart from a suppression argument under the Fourth Amendment. They're related, but they are separate. This was after I'd already made my argument regarding suppression, and now we're taking evidence after I've made my argument that goes to suppression and not to Frank's. So,
I asked y'all if y'all wanted to do this.
right, and it sounds like Ms. Stifler does want to present evidence. I would just ask that to the extent that there's additional testimony from this witness that is relevant to our suppression argument, that we be permitted to respond since I've already made
I
my
have
argument.
absolutely no problem with that. They filed one motion for 3 devices and 2 issues. It didn't break it up in that order because the state's position is that all of this is one analysis. Or at the end, there is a Frank's assertion that I don't think they've met, but I do think the detective has relevant contextual background information in regards to these devices. The court is adept at digital evidence, but there are some courts that are not. appellate courts might not be. The state wants to lay a proper record explaining what these things are.
Okay, I don't see any harm in it. Go ahead. I'll overrule it. Go ahead.
I'll be more targeted in my question.
Okay, like, I mean, if that's your purpose, ask it, okay? Like, ask it. Okay.
Detective Padilla, can you explain to the court how communications are stored in an iPhone?
Depends on the type of communications, but it could be in the underlying application for the app, say simple messages. Might be a native application, it could be a third-party application. It could be a variety of applications you wouldn't consider, you know.
In your training and experience in executing search warrants with the Jacksonville Sheriff's Office CFIU department, have you analyzed data in which you have found what would be termed communications between individuals in a manner other than native messaging?
Absolutely.
Can you give the court some examples?
Screenshots of text messages. I've seen them in gaming applications. I've seen them in regards to digital cell phones. What I wouldn't call communications, but I would call evidence of communication would be in underlying other databases like the intents and the knowledge C databases and the biome data structures. They show records of communications, but not necessarily the content of those communications. And those are things you wouldn't get through the logical extractions or select categorizations.
Did you say biome?
Biome, yes ma'am.
Okay.
B-I-O-M-E.
Thank you.
Somebody deletes text messages or other term communications, or even files, photos, voice memos, voice messages. Is there a way to potentially recover deleted data in a cell phone extraction?
Yeah, the vast majority of cell phones are predicated on a SQLite database, which is a data structure, kind of like a spreadsheet that are interlinked with each other, so you can do different queries on that. When you delete something in a database, it's not deleted, it's marked for deletion, and at some point, those databases could be vacuumed out and then cleared. So those deletions would be maintained in those databases until other processes created the actual deletions.
If you're able to recover deleted data in a database, does it always have metadata?
Not always.
Can you explain to the court what metadata is?
It's data about data, so basically it's your timestamps and your in case of messages, it might be the direction of travel, was it received or was it not received, or was it
From a
sent?
forensic technological standpoint, two people could be communicating within a specific time frame. If they delete those communications, they might not have metadata.
Correct.
So if you put a time limitation on a search, you could be missing communications within that time frame because they've been deleted and no longer have metadata.
Yeah, if you strictly say I only went from this date to this date, the system is going to look for those dates, and if there's no dates associated with those artifacts, it will not necessarily pull those.
And when you receive a device like a cell phone or an iPhone and do the initial extraction, is there ability to go back to that device later and do a second extraction?
Yes, you could go back to it later. The problem is the data is in flux, and as I spoke about the databases, cleaning out databases, time creates problems for us, because if you do an extraction on Monday and then do it again on Friday, you're going to have the databases are in different states, and some of that data that we're looking for, the deleted data, may be gone.
Detective, are you aware from your time with the Computer Forensics Unit and other detectives you work with and testifying in court of a defense of, I wasn't holding my phone, it's not my phone, it's a community phone?
Yes.
And as a CFIU detective, have you been asked in cases to testify about what we call indicia of ownership of a phone?
Yes, it's when we look at the data, you can always look at a text message, and we can say that that messaging app sent a message or received a message, but there's no context as to actually sent the message. Unless you're standing there watching the person do it, you're going to have some kind of attribution, and we would use other artifacts on the device to help prove that.
And not everyone's phone is in their name as a subscriber or their email address as a username in the extraction.
That's correct.
So there is the ability to obtain other evidence surrounding communications in order to determine who is making those communications at a certain time.
Yes, I'd be looking for things like what banking account were they logging into, if they taken pictures of themselves, do they do other activities that might indicate who that user might be.
Let's let's talk about Apple. Apple is a third-party, non-law enforcement corporation, correct?
Correct.
So do they require search warrants for law enforcement to receive content?
They do.
And are the search warrants being used here in Duval County? Generally, I won't say like a template, but for the information that is requested of Apple, are the search warrants here that the Jacksonville Sheriff's Office and other law enforcement agencies use based on the legal requirements of Apple Corporation?
Yeah, Apple creates a legal guide for law enforcement, and a lot of the terminology is taken right from their guide.
And does Apple have the ability to reject a search warrant if it does not comply with their legal requirements?
Yeah, as listed in their guide, they actually have a legal compliance team that will review these warrants, and they will determine if it's, in one of their statements is, if it's overbroad, they will reject, they will object, or they will deny that warrant.
You explained to the court what kind of data an Apple iCloud would encompass.
Generally, the backup of the iPhone, if it was submitted up there, will have records associated to any other device that they may have synced up there. It has, messages potentially, some of the content of devices, and anything else that that user has paired with their Apple ID.
Based on your experience, does Apple have the actual ability to limit a return as to content or time restrictions if you were to submit it?
Sustain, you can back up.
Have you submitted and received search warrants and returns from Apple?
I have.
How many would you say in your career?
Too many to count.
And in that time, have you become generally familiar with the types of returns you're receiving from Apple Corporation in response to search warrants?
Yes.
Or consent, or implied consent?
Yes.
And have you in the past yourself requested or have known fellow detectives to request a restricted return from Apple, as in whether it be subject matter, categories, or time?
They usually are pretty good about complying with what requested, but from my experience, what I've seen is they generally work off their own records, and they will send you whatever is available to them. They don't necessarily always limit to a certain time frame.
And in terms of selective categorization or asking Apple for only specific categories of data, have you, in your experience, seen that done successfully in a return from Apple?
I don't think I've actually limited to that limitation. It's usually give me all the data associated around at most the time frame.
And because an Apple iCloud is a backing up of a phone device, is there also, can you speak to how communications would be stored on an iCloud?
I can't speak to how they store it, but it's basically a server that's connected to that user, and a variety of different ways. One of it is an iTunes backup. You've probably heard that term before. The phone does a backup, and it will update and upload it to the iCloud. Because the iCloud's not it's a data storage center is all that is.
The hard drive in the sky.
Yes.
And does Apple categorize people's data for them when they upload it to an iCloud?
Can you establish if he knows?
You reviewed returns from Apple that categorize data.
Yes.
And have you any knowledge, personal or from your experience in reviewing these in general, what types of categories you have found in Apple returns?
Pretty much the same thing you'd find on the phone. Text messages, databases, I'm sorry, not databases, data structures such as messaging, pictures, media, everything that would store records about their applications that they've installed, payment records.
What's the basis of his knowledge? I think that was the objection.
Observation of returns he's received, categories he's seen on returns he's received.
From Apple? We maintain the objection? I'll overrule it. You can go ahead. Go ahead. To the base, to the other, I heard all that. So to the other question, which is, does Apple categorize in returns? I guess was a question. I can go back up specifically.
Yes. They do provide it to us in a categorized list, so I'd have to make the assumption that they're categorizing it.
And because it's a backup of a phone, similar to a phone, are communications stored in various data structures or categories other than, for example, text messages.
Yeah, as mentioned before, it's really up to the user of the device how they choose to communicate. If they are using only communication designated devices or applications, they're always going to be there, but it's up to the subject. They could use pictures, they can use, any other kind of tool to provide communication, even though it's not designed for communication.
Like third-party applications.
Yes.
So if you have a third-party application that you're using to communicate, like TextNow, WhatsApp, et cetera, it would not show up in your native messages or text messages on your phone or iCloud.
Yes, those are third-party applications that are designed by other entities other than Apple.
Okay. Turning to Google, have you had the opportunity in your career to submit search warrants, implied consent, or consent to searches to Google and receive returns of digital data?
I have
And how many times would you say in your career?
quite a few.
Now, Google provides data in a different format than you would get from a device extraction or an iCloud. Is that accurate?
Yes, but similar.
And when you parse data from an iCloud or from a device, you use generally Cellbrite or GrayKey.
Well, Celebrite is a technology that has an extraction and a decoding and a parser, and GrayKey is more of an extraction process.
When you are creating a UFED reader report, you would parse that through this parsing aspect of Cellbrite in order that it becomes readable as opposed to just ones and zeros.
Yeah, we use Celebrite Physical Analyzer, and it decodes the data, and then it parses the data.
If you were to take, I'm going to call it raw data from a Google return and parse it through Cellbrite, would it capture everything and categorize it correctly from the raw data to the reader report?
Everything, no, but everything that the program was designed to capture and decode and parse.
To your knowledge, having submitted search warrants to Google, do they also have a law enforcement guide and law enforcement portal,
Yes,
similar to Apple?
very similar.
And do they have what they call an independent legal team per their website that reviews warrants produced to them?
They do, and as stated, as Apple does, they review it for a variety of things and will reject it or contest it if necessary.
And like your Apple search warrants, are the search warrants being used by law enforcement agencies here in Duval County and the 4th Judicial Circuit incorporate that language that's required by Google into the affidavit and search warrant?
They do.
Have you ever requested or received a return with a temporal restriction for a Google Drive?
I do believe I have.
And did Google comply with that temporal restriction to the best of your knowledge in the cases where you've received one?
Yes.
To your knowledge, does Google have the ability, based on your experience in the returns that you've received and the warrants you've submitted, to do a selective categorization of data?
So I can repeat that.
Based on your experience in sending search warrants, implied consent, or consent to search to Google and receiving returns, does Google have the ability to do selective categorization of data?
I would have to assume they do. I don't know their workflow, but I have received limited data in the past.
And for Google Drives, can you advise the judge what types of data you would find? Like iCloud is a backup of a phone and other devices. What is a Google Drive? What does it contain?
It's essentially the same thing as iCloud. It's just a different terminology they use. And you'd find the same things you'd find in an iCloud. It's everything that they have linked to their Google account. It's more specific to a Google account than in the Apple infrastructure, but it will contain the same things: messages, content of their devices, content of their photos, and backup anything they choose to back up.
And an iCloud or a phone with email application, same with Google, they would contain someone's emails,
Potentially, yes.
their messages,
Yes.
their applications,
Yes.
photos,
Yes.
IP addresses,
Yes.
usernames,
Yes.
bank accounts, credit cards,
All the above.
documents they may have saved,
Yes.
voice memos,
It-
voice notes,
Correct.
notes application,
Yes.
and whatever is backed up or in the hands of these third-party providers is what the user has created, correct?
Yes, on both Android and iOS, there are settings to determine what you choose to back up. So they could self-limit what they back up, and the Google or iCloud would not get that data.
There is some data that Apple and Google captures that the user can't create, like your IP address, for example.
Correct.
If we're talking about content, generally it's content generated by the user, like your text messages, your communications, your photos, the content of those items.
Correct.
So when Google or Apple or a phone are holding that content, it's based on whatever the user potentially categorizes as that.
Yes.
And in terms of what we talked about earlier in regards to devices and cell phones, timeline features and other artifacts that indicate the user or the possessor, because they're cloud-based, do they have the ability to hold other data not relevant to a particular individual if that individual has several devices or other people have devices connected to that cloud?
If you're asking, can it have other devices associated to that same count? Yes.
I have a moment, Your Honor.
Yes.
I have no further questions.
Ms. Nelson?
Good afternoon, Detective.
Good afternoon.
Do you want to use this? I don't know. You're okay over there? You can see me?
I'm okay. Can
Okay,
you hear me
right.
okay?
Okay. Right.
I want to start with iPhones. You and I had talked previously at your deposition regarding different methods of extraction, and Ms. Stifler asked you some questions about it. As I heard you explaining, there is at least a two-step process for iPhones. And what I mean by that is there is the actual extraction of the data. Is that right?
Yes.
And then after you extract the data, meaning take it off the device, that's what extraction means.
Yes,
After you do that, then there's a second step. Is that right?
there is.
And that second step can take a couple different forms, if I understood you correctly at your deposition, so correct me if I'm wrong. I heard you say today you can parse the data, right? As part of
Yeah,
step
the
two?
tool decodes. Decoding is basically putting it into a human readable format, where parsing is making sense of it.
Thank you. So we have the second step, which is decoding, which the program does for you.
Correct.
And then there's the first, I'll say, kind of human step to understand that data, which is the parsing.
No, the parsing is also automatically done.
Okay, so,
Give it to context. If you were to decode a database of messages, it would be just a long string of messages with a variety of different contents. And you'd have to string together this table to make sense of it. When you parse it, it'll show you, like you would see it on a phone, that this message came from this person at this time. But all those elements are not kept in one spot. They're kept in various tables in the database.
perfect.
So the parsing is to bring them all back together.
So once we parse, after that, then we meaning a human, can look at the data and make meaning of it.
Yes, that's when analysis would take place.
So analysis. So when you extract data, you don't necessarily have to parse it, right?
Correct.
And when you parse data, you don't necessarily then have to analyze it, right?
Correct.
So if I extract a cell phone and then I choose to parse it, I could just have that information sit there,
You could.
right? And I could also then extract, you said multiple times, from the same device,
You could.
right? And then I could take those separate extractions and I could parse both, not parse one. I could do lots of different things with them, right?
If you feel like wasting your time, yes.
Fair enough, based on your time and resources. And then even if I have two extractions, I could take one and I could analyze it and limit based on time or subject matter, right?
Yes, but you could do that on either extraction.
Fair enough. Leaving the second extraction completely untouched, right?
Yes.
So that way, if I found information that would lead me to believe that more systems within the phone or a broader time date range would be relevant, I could go back and get that information, right?
You wouldn't necessarily see that if you didn't have the information to look at in the first place.
Right, which is why we'd have that second extraction, right?
The extraction would be the same as the first, other than variances in the database structures.
Exactly. I think we're saying the same thing in different ways.
I don't think so.
Okay,
If you extract it here and extract it here, the data is the same. You wouldn't need the second extraction to do what you're saying over here. Over here. They're the same.
we agree. Thank you. So if we're talking about this multi-step process for an iPhone, still want to focus on an iPhone. I believe that you testified that once you extract the data, you have the ability to just look at, for example, a certain category of information.
Yes.
You have the ability to look at just a certain date range, correct?
Yes.
You also have the ability to look at, for example, communications only between number A and phone number B,
Correct.
right? There are lots of different ways that you can cut this data.
Yes.
And you could still have the ability, like you just said earlier, to go back and look at the whole universe, correct?
Yes.
I just want to be clear, when we're talking about the iPhone in this case, you did not perform any of the steps we just went through on Ms. Gardner's iPhone.
No.
So you cannot give this court any information about whether messages or communications were located in different files in this specific case within the iPhone.
That's correct.
Let's move on to iCloud accounts. You've never worked for Apple, I assume.
I have not.
And you understand that when you receive a return from Apple, that it has different categories of information.
Loosely, it's organized in some fashion, but it is very convoluted and very hard to read in the format they provide. But there are categories, if you will.
So for example, you would typically see for an iCloud return customer information.
Yes.
You would typically see connection logs with IP addresses.
Correct.
You would also typically see something that could take the form of backed up messages, like text messages.
Yes.
You would often see something that would take the form of backed up, I'll say SMS messages to the extent that they aren't in your iMessages. That might be a
Potentially.
separate folder, right?
Potentially. A lot of it is buried within the backup files that are associated with those categories as well.
That is a fair point. So we have information that comes from backing up the iCloud that would be returned, right?
Well, not backing up to iCloud, backing up the device.
Backing up the device.
To the iCloud.
You would have that category of information, right?
Yes.
You would also have other information that Apple captures, correct?
Yes.
And that other information might be metadata, data about data, right?
Yes.
It could also be information about logins to the iCloud account,
Potentially.
location data,
Potentially.
and that would be separate and apart from any sort of iCloud backup, right?
Well, it could be combined in the backup too, because the device itself does record location data, and that would be in the backup potentially as well.
And I think you testified earlier that you are aware that Apple has its own guidelines for law enforcement. Have you reviewed those guidelines?
Yes.
And so you're aware that Apple encourages anybody who submits a subpoena or a search warrant, so whether it's civil or criminal, to be as precise and narrow as possible.
Yes.
So they have the ability to respond without the entire account.
Potentially. Again, I don't work for Apple. I don't know what the capabilities are, but I have seen limited returns in the past.
Well, you've seen limited returns from Apple.
Yes.
Did you author those affidavits?
I did not.
But you reviewed the search returns?
I have seen several, yes. Not recently. Apple's been a long company with a long history, and sometimes they change things, and they routinely change their databases. I've seen in the past where you've asked for a narrow scope, and you get everything. I've seen in the past where you get narrow scope, and you get some. Again, it's up to Apple what they provide.
And when you saw a narrow scope, was it limited based on time and date?
Yes.
Did you ever see returns that were limited based on subject matter?
I have not.
So the only restrictions you've ever seen are date and time.
Correct.
I have a brief indulgence, Your Honor.
Yes.
Thank you for your patience, Detective. For iCloud returns, when you receive the information from Apple, is it in a human-readable format?
Oh, gosh, no.
Okay, say more about that.
It is in a very convoluted, it's an encrypted container that comes originally to us, and it actually has to go out to the iCloud and pull this down from their system and decrypt it. And then it is put into a very convoluted process. And then we take that and load it into our analyzers in order to make it into a readable format.
And once you put the information you get from Apple into your analyzers and get it into a readable format, is it a similar process for what we talked about with the cell phone?
Yeah, it's the same tool and does the same thing. It just utilizes a different input.
And so as part of that process, you could limit the amount of information you look at,
Yes.
and you could still go back to that information later and look at the entire universe. Is that fair? I think we covered this about iPhones, but just to be sure, for iCloud accounts, when we talk about limiting the type of information that you could look at, that could be by date,
Yes.
that could be by people or users,
Yes.
right? That could be by keywords,
Yes.
that could be by locations, like geotags, for example.
Yes.
That could also be by phone numbers, right? And the same is true for cell phones,
Yes.
right? Let's talk very briefly about Google accounts. When I talked about the ability to limit what we look at from Google, I want to ask you the same set of questions. When you get returns from Google, are they in a human-readable format?
It's better than Apple's, but it's very convoluted as well because they have their own proprietary format. But it is human readable if you can figure out how to parse through their data manually. However, it suffers from the same problem Apple has. It's basically just a data dump. And so you'd have to use some kind of analyzer in order to make sense of it.
And once you do the analyzer, as you just said, and it's in human-readable format, are you also able to then parse the data?
Yeah, same rules apply.
So it's exactly the same as what we just talked about with the iCloud account?
It is.
And that's exactly the same as what we talked about with the iPhone?
Correct.
I'd like to fast forward a little bit and talk to you about the process for when you receive a warrant. You testified earlier that when you receive a warrant, you look it over before you look at the device to make sure you're in compliance with the warrant. Did I understand that correctly?
Yes.
And once you review the warrant and you go into the device, we can use a cell phone as the example. You're going to review the cell phone. If the warrant says something along the lines of any and all information about who owns this cell phone, are there any standard operating procedures in the department that give guidance to what you can or cannot search?
No, because that's a very subjective term when you say device identifiers. It could be as simple as the device ID, the account information, but you also have to look at the context of the device. What activities was that device being used for? You're going to look at what user accounts to other third-party applications are out there. So you couldn't just say it's just the device identifier you're looking at. It's the breadth of the device is who's using the device, what applications are there. Like take a banking account, for example. who are the user accounts associated to. So you'd have to look at all the totality of all that kind of stuff to really make a concerted effort to say, this is the user.
So if I understood your testimony earlier, again, using whose device is this as our example, that could mean you're looking at lots of different folders and files. Is that right?
Potentially.
Potentially. Let's name a few if you're trying to identify whose device this is.
Like I said, I'd first start with the ownership of the device. Who's the account holder? It'll have, an email address, and it'll have the phone number and that kind of stuff, the serial number, the IMEI number, the MSN number of the phone. All those are your basic subscriber information. And then on top of that is, if I'm trying to attribute that to a particular person, I'm going to be looking at financial records, social media accounts, third-party applications, where are all the user accounts. It's safe to say if every user account's the same email, that it's probably the same person using the phone.
You might look at if they had medical records stored on their
Potentially.
phone, right? You might look at if they had copies of driver's licenses stored on their phone, right?
Yes.
So pictures, emails. You would essentially look everywhere that you could find information on the phone. Is that fair?
Potentially.
And I think I heard you answer my question, but I want to make sure that I heard you correctly. Are there standard operating procedures at your department for where you can and cannot search as part of that process?
There is not. There's best practices that we adhere to, but there's not a standard operating procedure. Every device is different. Every case is different.
And so if a forensic examiner is reviewing, again, we'll take our cell phone, there aren't any specific guidelines for what he or she should or shouldn't look at as part of that process.
No, but you gotta understand, the vast majority of the stuff that we look at, we're extracting the data, putting it into a reader format for an investigator who's linked to the case to review. I don't know the facts of the case, so a phone number may be relevant. I wouldn't know it. So I'm not looking at the data. I'm passing it off to the investigator to look through the data.
And does the investigator have any standard operating procedures to follow if you know?
I do not know.
You don't know?
No, I don't think there's anything in writing. It's based on the case. If you're looking to determine ownership, you're going to look one way at your leads. If you're looking at, pictures of drugs, you're primarily looking at photographs. I mean, it's going to be case specific. So there's not really a standard operating procedure. It's more case driven.
Mr. Carodi reminded me that I forgot to ask you some questions about the analysis piece of an iCloud account, a Google account, or a cell phone. To the extent that your answer is different based on the device, please let me know and I'm happy to ask the question differently, okay? So once we get the information into human readable format, we talked about your ability to then focus in on certain categories of information, right?
Yeah, whoever's looking at the data has the ability to filter down to whatever they feel like filtering to.
And as part of that, can I call it the filtering process? As part of the filtering process, that could take anywhere from a couple seconds to a couple minutes, right?
Take longer depending on the amount of data that's in there, yeah.
Sure. A typical cell phone, it's not going to take weeks
For the filtering or for the processing?
for the filtering.
It shouldn't. Depends on how much you're filtering. If you're only wanting to see a particular phone number and you filter it, it takes seconds. But if you're wanting to filter on 80 different things, it may take you multiple steps of filtering to get to where you're going, and that could take weeks of looking through that data.
For the computer program just to run the filter, let me be more precise. Approximately how long would that take on an average cell phone?
It's almost immediate. It goes through and looks through the data. However, most of the filtering is either a single filter across the entire data set or through a certain artifact, say a messaging app. If you just want to look through the messaging app and you want to say, give me all these phone numbers, it'll show you just that application. But if you wanted to look for that phone number across the entire device, then that would be a different search. You're not really saying this phone number and. It's usually one or the other.
further questions. Thank you, Detective.
Briefly.
Okay.
This is just a couple questions in response to what Ms. Nelson asked you. If you were to limit a search by filtration, however, through Apple, iCloud, Google Drive, or a phone, or so only specific keywords, that presumes that those keywords are legitimate.
It presumes that those keywords are actually in the device and/or valid to the case. Yes.
So if I ask you, Detective Padilla, will you search this phone for the word murder? That's presuming that the people talking about murder use the word murder as opposed to a code word.
Yeah, it wouldn't use any kind of aliases for the word murder.
Or if we're talking about specific communications between two phone numbers, that's presuming that they're communicating with someone who's using a phone registered to them or a known phone number.
Or using the native phone app. If you're using another third-party application, there might be a different phone number associated.
So if you're using Snapchat to communicate, or social media, or WhatsApp, or any third-party provider, or gaming application, it might not come up if you search with a particular phone number.
It more likely would not come up.
And if you were looking for communications between individuals based on their names, that would presume that the person using the device has stored that person's name as their, what we call, in this line of work, government name, correct?
Correct.
Okay. There are ways, in your experience, people use devices to communicate in non-traditional, non-obvious manners. Is that fair to say?
Absolutely.
Thank you, Your Honor. No further questions.
I have a couple. Give me a second. I just want to make sure I'm understanding your testimony, okay? I think where I got a little confused was, so there were questions about your experience with iCloud accounts and then the return back. I think I heard two different things. So you have experience where there have been limits on the warrant and Apple has sent back curtailed data, you said that's hard to read. So you have had that experience. So if it is sent out in a limited fashion from the issuing court, you have gotten returns back from iCloud. Because I heard you say Google, but I heard, I think, two different things, and I just want to make sure what your true answer is.
It's hard to tell what they limit because they don't come back with a, here's what we gave you. It's basically a data dump. But you can kind of look at the date ranges and go, okay, well, these only start here, so it had to have been limited, is what I think I'm trying to convey. They don't say, we only gave you the text messages from this time frame. They basically send you a copy of the warrant that comes with it, as well as some delineation in there, but there's really not a lot of, this is what we limited it to.
So how are you deducing that fact? So you're saying that you get the information, then you look at the warrant, and then you look at, once you extract it, you have those two time frames, and you say, oh, they must have limited
Yes.
based on the warrant.
Right,
That's how you're deducing that information.
absolutely.
Okay, and then I also heard you say that you have, I guess, reviewed the warrant. It's asked for a narrow or precise time frame, and then it says, I have the experience to where the warrant says something narrow, but you get everything.
Yes. That has happened.
Okay,
To clarify a little bit though, if our warrant is specific to a time frame and we get more back from them, it is my responsibility to limit the report back to the investigator. Because as I mentioned, I don't examine them for the most part. We might interpret data for the investigators, but we're not looking for evidence because I don't know anything about the case. But if the warrant says this date to this date, when I
And you get everything.
report, I'll get everything from the extraction or everything iCloud gives me. I will limit the date range to only the artifacts that contain that date range or anything that does not have a date associated to it, and that would be presented to the investigator. So they would not get anything that would be outside of that scope.
and so I think that's where might have stopped you. So that's what you're saying, you look at the warrant, you look at what the extraction is, and then you only provide what the warrant gives you authority to provide to the detective,
That's correct.
even if you get everything.
Exactly. Because we represent the data, not the investigation.
When Ms. Nelson was asking you questions about the multiple steps, so I only got to two. So it's extraction, and then there are two automatic things that occur. I just want to make sure I'm understanding you. There's decoding and there's also parsing.
Yeah, and in a
Is there another step?
analysis, but that's.
Analysis.
That's the investigator's role. There's also interpreting of the data. That would come back to our unit if the detective says, hey, I want to present this piece of evidence. Can you help me make context to where it came from, how it got on this device? And we would offer our services to help interpret that data.
Okay. That's all I had. Are there any questions based on mine? Okay, thank you. All right, let's take 10 minutes. Okay, court's in recess.
Yeah, that last one.
that have taken this issue of how modern courts interpret the Fourth Amendment when it comes to digital data because of the nature of devices and phones and iClouds and Google returns and the types, an enormous breadth of data and information that is captured in these that distinguish them from what we consider traditional Fourth Amendment analysis of the search of for tangible property in a fixed place, search of a home, search of a car. But in McCall, the court gives a lot of analysis and insight into this, that courts themselves struggle with how probable cause and particularity apply to information that law enforcement collects from a cloud account. And note that it would be unsurprising that the police officer would struggle as well. And ultimately, I will end, or begin with the end, which is no matter what the court thinks about the Fourth Amendment and cloud data and temporal restrictions and selective categorization, ultimately, all of these cases, all of these courts, and Your Honor should land in the same place, which is that these warrants are sufficiently articulated. Like the Wiretap application, there is an extensive discussion of the objective facts of this case. There are facts in these warrants not only about their participation in a premeditated murder, a child abuse, a conspiracy, but also an articulation that these individuals, based on what the applicant knew at the time seeking these warrants, were using alternative means of communication to speak to one another about the death of Jared Bridegan, the possibility of financial transactions, arrests of individuals. There are articulable and specific facts outlined in here that several of these individuals, Ms. Gardner, Ms. Jensen, perhaps Mr. Biggerstaff, Mr. Fernandez Saldana, are talking on wire intercepts about their phones being tapped, about using FaceTime, about looking for other ways to use other phones to communicate, about going to a neighbor's house to use their phone to communicate. So in seeking communications, the reason I had to testify is to give this court an idea that people who commit crimes don't use text messaging, their native messaging to text their co-conspirators from their own phone number, in their own name, to their own name, saying things like, hey, want to go commit that murder today? That defies common sense, it defies logic. The reason the state seeks and should be allowed to look for information in places other than the selective categories that defense would like us to is because people tend to hide evidence of wrongdoing. They tend to delete it. They tend to circumvent traditional methods of investigators finding communications. A phone and a Google return and an iCloud are based upon what the user knows, how the user defines someone in their phone, how they tag them, how they name them, which applications they use, what they delete, what they keep, what they screenshot, what they send, what they record on a voice memo and send. So it's not unreasonable, given the government's compelling interest in investigating homicides, that an investigator would be able to look in places other than native messages or keyword searches for a murder between two known phone numbers. The same way that if Your Honor were to give a search warrant to a house to go look for a letter about a murder, detectives can look through every piece of paper and every filing cabinet in a house, regardless of whether it's in a drawer that says kindergarten report card or medical records or tax documents. In some of the cases I've cited for Your Honor is because we, the state, and investigators should not rely on the defendant's own categorization of their evidence of wrongdoing. We should not be stuck. We should not be handcuffed because they have taken steps to delete or hide or circumvent traditional investigative means or use other ways to communicate that are surreptitious. The affidavits in this case, Your Honor has to do a case-specific analysis. The affidavits in this case clearly establish probable cause that these people are involved in a premeditated murder for hire that would necessarily involve relationships between parties, long-standing relationships, communication seemed to be a spur-of-the-moment crime, it makes sense that they would request a larger time frame for a cloud return because there's a pre-existing relationship between this individual and the people he called who came in and committed an armed robbery at his beck and call. They said it was reasonable to look into some co-conspirators or co-defendants' pre-existing relationship to establish his knowledge, participation in this robbery. It is not reasonable to believe such a relationship will be reflected in the data stored inside McCall. So McCall, to me, is the one that the court should look at the most. It's one of the most recent cases. It is specific to a cloud account. It talks about a fact-specific analysis that even in a case like this where they know that the communications between them that day are not going to be on the cloud because of the way it was backed up in this case, that because of those relationships, it makes sense to go back to the court. It also talks about how a subject matter or categorization limitation makes very little sense. And I understand the defense point that this is a broad search warrant and we've gotten all data, but I will tell the court, the state of Florida is not standing up here holding an arrest warrant affidavit and arrest warrant that says entirety of iCloud is property being sought. There are specific categories outlined in each of these warrants. Do they cover the majority and bulk of the data that would be contained in these devices or clouds? Yes, but they are specifically delineated. This is not a mere fishing expedition, and what they're looking for is communications, and they are specifically discussing categories of data that would include communications. They specifically say, for talking about the iPhone warrant, number 10, communications between parties relevant to the offenses, concerning payments relevant to the offenses, related to the offenses. They're specifying as best they can, but as the McCall court understandably realizes and outlines is that in today's world, culling digital evidence is nearly impossible when you're talking about subject matter because of the way people store data and the way people communicate. In United States versus Blake, the case cited by defense in their motion, that court says that they're talking about social media, Facebook warrant, that it's not open and shut whether this was overly broad. And then they find that, if it's not open and shut for these courts and we're doing a case-specific analysis and intelligent magistrates and intelligent appellate courts can disagree, then it's unfair to dock the officer for relying on a judicially approved warrant on these issues. And the whole analysis for probable cause, it's not a hyper-technical consideration, it's not a legal technician, it's a real consideration. A real person reading this warrant and conducting a search based on it would not think these are facially deficient because magistrates themselves can't always agree. But it is worth noting as well, Damon's is cited by defense. In Blake, McCall, and Damon's, the warrants before the court are very different than the ones that are announced in front of me in this Gardner case. And I've provided the remainder of the filings, Ms. Nelson cited a portion of the trial court order in Damon's. I have provided the actual trial filings from that case, including the suppression motion number 1, which is to a phone, and suppression motion number 3, which is to an iCloud. Those include the warrants that issue in that case. And when Your Honor reads those warrants, you'll see a vast difference in how thorough and in-depth those ones were compared to the ones we have here. I mean, in most of these cases, the court, from McCall, they didn't put any kind of restriction on the iCloud. They didn't put a date restriction. They didn't put a content restriction. They asked for the entirety of the iCloud. And the court said that was still proper. They received 2.5 months just based on when it was created. They said that was still proper given the coexisting relationships. But here, the state did act in good faith. The officer did put a temporal limitation in those warrants. He even put a paragraph in, I know Ms. Nelson called it the attempt to save a deficient warrant in her motion, that your applicant understands this is a longer time period than would normally be requested for digital data. However, based on the nature of this case, not directly, based on the nature of this case and the presence of the co-defendants, the fact that we allege this to be a murder for hire, the applicant expects that there will be relevant information in a longer time frame, just based on the circumstances of this case, the number of participants, and the evidence these people are communicating the account and had no limits for dates. Here we have limits for dates. So their cases are distinct. Here, the applicant has done exactly what McCall and Blake have required, which is trying to make some kind of meaningful limitation while still getting the evidence which they're seeking that they would be entitled to given the facts and circumstances. I cited United States versus Brooks, 427 Federal 3rd, 1246. That's a 10th Circuit Court of Appeals. It's talking about, in this case, that digital searching is as much an art as a science. And that's the purpose of Detectivepedia, again, that we're not looking through financial documents where you can control F on a PDF and find what you're looking for by keyword search. We're talking about sophisticated individuals who are using code words, using applications, hiding their communications. So by nature, where we're looking is going to be broader. U.S. v. Burgess, 576 Federal 3rd, 1078, 10th Circuit, talking about sometimes because electronic files can be labeled, relabeled, that we have to look at all files sometimes to find the ones we are seeking. U.S. v. Farlow, 681 Federal 3rd, 15, that is a First Circuit Court of Appeals case which discusses that computer files can easily be renamed, file extensions can be changed, and therefore sometimes the investigator, the searcher has to look in more places than one to find what they're looking for. And this is really to look for what the communications at issue. The identity of the individual making a statement, the identity of the declarant is always going to be relevant to an investigation. I have been on homicides, I know this court has done trials where people bring forth defenses of that may be my phone, I wasn't holding it, you can't prove that's my phone, somebody else was using it at the time of this homicide, phones where people's names aren't the subscriber name. Times where individuals come up with a defense of it's a community phone, it's being passed around, somebody else is holding it. So indicia of usership and ownership and possession at the time those communications are being made is always going to be relevant. How else is the state of Florida going to get a statement into evidence of a party opponent without establishing that the party opponent was using the device at the time of the statement? I also provided the court with some cases regarding that type of analysis. State v. Arnago, 973rd, the 3rd DC of Florida. That case actually involves a physical search where officers were trying to determine in a grow house for marijuana the individuals inside who was responsible, who they were going to charge, and they collected cigarette butts, beer bottles, and fingerprints which were located in close proximity to marijuana plants. And the court there found that evidence to ascertain identity is reasonably within the scope of a search warrant, even if not specifically outlined. So even if we're not specifically outlining some of these things in the warrant, which they are for the most part generally outlined, any indicia of ownership is always going to be relevant, is always going to be reasonably contained within evidence that this person is making these statements. We're asking for communications between Ms. Gardner and her co-conspirators. We have to prove the communications are between Ms. Gardner and her co-conspirators. U.S. v. Bass, 785 Federal 3rd, 1043 also discusses indicia of ownership that the police can seize more when it's unclear what format evidence will be in. Again, if we're looking for communications, we're not limited to native messages. Communications can be in multiple different types of formats. United States v. Salaman, 742 Federal 3rd, 221. That's the United States District Court of Connecticut. They discussed that law enforcement has a strong interest in determining who owns the phone or is using the phone and linking evidence to a particular individual. And this all cuts exactly to the argument they're making, which is establishing a nexus between the individual and the evidence being sought. U.S. v. Richards, 659 Federal 3rd, 527, the U.S. Sixth Circuit Court of Appeals, that detectives doing a digital search would not know the format of a server at the time of the search, so there would be multiple different servers, and they found that was not local fraud. So the case law is clear that a reasonable limitation is sufficient. They favor a temporal limitation because I would love the court to look at these suppression motions with the attached warrants and see that they are much less detailed, much less specific, much less articulated than the warrants you have before you. And in that case, the court imposed some limitations because none were imposed and severed parts of the warrant, and the appellate court upheld it. Same with McCall, same with Blake. So those appellate courts allow the evidence to be used at trial with warrants that are far less detailed and sufficient than the warrants Your Honor has in front of you today. Lastly, I understand, although not controlling, and Ms. Nelson gave you a magistrate's order from Broward County, I have provided a motion to reconsider an order on reconsideration of a circuit court decision here in the Fourth Judicial Circuit, State of Florida versus Henry Landon. It discusses NETA, which would be a Facebook return, and similar issues where the defense was attacking the warrant as overbroad and not particular. That one did include a time limitation, and the presiding judge in that case.
You put it in these materials, I haven't looked through this binder.
Yes, sir. Everything that I'm referencing is in the
Okay.
binder and has been provided to defense.
I haven't had a chance to look at that.
That was in Division CRH, and on November 2nd, 2023, the order denying Judge Brandon wrote, asking to look through all data for evidence relevant, in that case to a kidnapping and assault, is not any different than looking through an entire file cabinet that contains all sorts of business files to find evidence that pertains to a distinct financial crime. The state was not required to ask NETA for discrete pieces of data or specific records. Time request to a specific account and date range where applicable is enough. On his motion for reconsideration and order denying for reconsideration, the judge also found that the police relied in good faith on the warrant issued, and that noted that the police did not skip a subject matter limitation in the warrant out of some nefarious plot to get more information than the law entitled them to do. Instead, they did what they always do. Use the basic form for these kinds of warrants. There's no misconduct on the part of the police here to deter. They acted in good faith, applying for the warrant according to standard procedures, including those imposed by NETA itself, and received and reviewed the responsive information in good faith reliance on the judicially approved warrant. An officer, ultimately, this is the state's position that these warrants are sufficiently particular, supported by sufficient probable cause, create a sufficient nexus between Ms. Gardner and the items being searched, and Ms. Gardner and the crime alleged, premeditated murder. We believe the time frame
they're submitting information.
Well, before we have a Frank's evidentiary hearing, the burden is on the defense to present.
Right, that's what I'm saying, like, so,
I would say they haven't met their burden, so there's no, you can summarily deny the request for Frank's at the end. We haven't proven, one, that that's even true, two, that it's material to the probable cause of the entirety of the affidavit, or three, that the officer intentionally left it out of the,
maybe I'm not being on, what my question is, I thought that there was a deposition that needed to.
that is a, yes, sir, that is, Mr. Dreiser's issues are separate from this.
You think, okay. Is it
Well, I think
agree?
so. Yeah, I confirm with Mr. Carruthers.
Sure.
He's on Zoom, all right?
No, it's a different Zoom setup, so that
Oh,
others
okay.
can talk. Unless you all can correct me if I'm wrong, I don't think anyone on Zoom can talk.
Judge, can you hear me?
Oh, I can, okay. Yes, I can. Well, I'm under the wrong impression. Hello, Mr. Dreiser.
Hi, Judge. I believe our issue is distinctly separate than this issue.
Okay. You agree?
Thank you.
Yes, Sean.
Okay. All right, thank you.
Yes, ma'am, thank you. If Ms. Stifler is finished, Your Honor, I'll make the
Yes.
argument. I'll pick up at the end with the Frank's hearing. I disagree that we haven't met our burden. I think we actually met our burden through Detective Padilla, who testified unequivocally that law enforcement knows they have the capability to not only request targeted information from Apple, from Google, but they also then, once they receive that information, they know that they have, meaning the forensic folks, have the ability to filter before it ever goes to the investigative team. Detective Video is very explicit about that. Not only that they could get it separately, but then the forensic unit itself could narrow that data consistent with any sort of search warrant before it ever goes to anybody with knowledge about the case.
I guess I have a problem with that because he was speaking kind of in generalities and I'm supposed to take that kind of general, I don't really know I don't know what to use that for. But, I mean, so you're, like, so he's saying in a general sense, but I don't know necessarily from this perspective, according to this case, that it's a case-specific finding. So you're saying I should take his testimony, apply to this case, that is a possibility, so therefore.
So if the court, our position is that in terms of whether the defense is entitled to a Frank's hearing, the answer is yes. And the burden is on the defense to show that we are entitled to one, and I believe that we've met the burden of showing entitlement to a Frank's hearing
Okay.
through detective.
Okay, I understand now. Okay, all right, I get it.
I apologize for not being clear.
No, I'm sorry, it's me. Go ahead.
If the court doesn't have any further questions about Frank's, I'll
I don't.
move back to Detective Padilla. I want to start with something that Ms. Stifler said, which was that law enforcement struggles with cloud data. That's not what I heard Detective Padilla say. It's quite the opposite. What he said is what I just said to the court. He was very clear. Law enforcement knows that they can get targeted information from these iCloud companies. They can ask for it, they can receive it. He explained the file systems to the court. Not only that, but even if they get a data dump, which he said sometimes they do, even when they ask for something narrow, they get something really big. He and his team, through their forensic software, knows how to narrow that all the way down by search term, by the person sending and receiving, by keyword, by file type. They're not struggling with this information, Your Honor. They know how to do it. So I don't think that we are in a situation where this is impossible or impractical. Detective Padilla said that filtering process takes a couple of seconds. And he also told this court that even after they filter and give it to the investigative team to look at and make meaning of, that original data still exists. It's still available. So if law enforcement, the investigative team, looks at that filtered data and they then find probable cause to get more information from that cloud-based account, from that cell phone, from that Google account, guess what? They can go back to that magistrate and say, now we have probable cause for a wider data range.
for more file systems, for more information. But what we are hearing today is that we should just be able to turn that information over. This court should just agree that even if there isn't probable cause, even if the warrant isn't particularized, and even though Detective Padilla and his team knows that they have the ability to narrow in, we should just turn it all over to the case team and let them go through it. And there's another really important thing that Detective Padilla said today, Your Honor, and that was that when you turn that information over, and I wrote it down, he said, we can look at whatever is there. And I asked him, you can look at this type of file, that type of file, pictures, everything. He said, yeah, we can look at everything. And that's what happened here. Despite the knowledge and the capability to narrow, the magistrate was never presented that information. And we have warrants here that are far broader than the probable cause for this vast amount of information, to be able to rifle through Ms. Gardner's entire digital life. And it certainly isn't particularized. I disagree with Ms. Stifler's characterization of both McCall and of Demons, D-E-M-O-N-S, I know we're pronouncing it slightly differently. In McCall, the district court, in fact, did find that that warrant violated the Fourth Amendment. And that is the case about the poker game where the poker game wasn't going correctly and then there was an armed robbery. And in that case, the law enforcement did in fact get the entire iCloud account. And the court said that's way too much. And then in fact, when the state appealed, the government appealed to the 11th Circuit, the state conceded that it was overbroad. And the 11th Circuit assumed that there wasn't probable cause because it was so overbroad. This isn't a case where the 11th Circuit simply said a temporal limit of any type is sufficient. That's not the holding of McCall. The holding of McCall is that the temporal limit has to still be tethered to the probable cause determination. What do I mean by that? We have the element requirement and we have the nexus requirement. And the time limit has to make sense. What that means in this case is that there is a time limit in the iCloud warrant. However, it's not tethered to anything meaningful, it's arbitrary. And that's where we see in the Demons case that the court said that's not enough. There has to be a meaningful limitation here. We don't have that in this instance. And the iPhone warrant, Your Honor, does not have any sort of temporal limitation. Finally, Your Honor, if we are talking about being able to look through somebody's entire device or entire iCloud account, Ms. Stifler said that indicia of identification is always relevant, meaning that that should be a skeleton key to look through every single piece of information. That is not what the law allows. To paraphrase the Supreme Court in Perpetuer v. United States, the court there said, it certainly doesn't take a very creative law enforcement officer to think for any excuse to be able to look through every single file in somebody's digital life. The court there also noted that the average iPhone, this isn't like searching somebody's house, where it's a narrow scope of information. This is like searching warehouses filled with data. And giving law enforcement the permission to look through everything within the entire warehouse, when perhaps all they're looking for is somebody's car keys. And we know today from Detective Padilla that they have the ability to narrow that scope as much as the law requires, still preserving their ability, if they develop appropriate probable cause, to go back and zoom right back out and get more information. So what we are asking this court to do today, Your Honor, is to grant Ms. Gardner's motion to suppress the iPhone warrant, the iCloud warrant, and the Google warrant, both because they lack sufficient probable cause and because they are not particularized. And this certainly is not a case where we should be discussing good faith, given Detective Padilla's testimony here today. unless the court has further questions.
Thank you very much. And so, I'm gonna take this under advisement. Do you all have a time frame that you're looking at? So, I wanna be responsive, but obviously there's, you're all giving me a lot to look at, and I need a chance to go through it. And I do appreciate y'all's patience. I wasn't expecting that trial to interfere with today, so I apologize for that. From your perspective, what would be reasonable? And I'll try to work under those deadlines. What I'm trying to ask is, I don't know what you all are doing discovery-wise and to comply with the court order that I've put into place. Like, I want to be able to not interfere with your ability to prepare and be responsive so that you all can kind of know the landscape.
The state has no restrictions with the water law. Our law takes your honor to review what we provided in the right orders, sufficient to state, so I'm going to keep, at least my oversight, our ability to prepare for trial.
So I'm otherwise kind of occupied next week. I want to give it to you.
So you're gonna file written orders? So I don't know that we need to come back if we get e-serve the orders. I was gonna suggest June 23rd, because at that point, the first motion regarding BB would either be moot or be right.
So what I'm considering is that might be okay, but if there is a need to have a hearing, bring some hearing, if there's a need, like, I don't, like, to me, like, everything is not necessarily tied up. I wouldn't necessarily resolve everything with the written order, so I don't want to give it to you at a point in time where we're pushing up against August. Does that make sense? And so I'll have it out by June 1st, but I'd like to have a court date associated with it, so then I'll try to get out before then, so then by June 1st, we can kind of figure out where do we go from here. And then,
So we're.
what
June
about
1st
just,
is a
I'm
court
sorry,
date? Are you saying June 1st is a court date?
I think so.
Yes, sir.
Just a pre-trial.
Yes, sir.
And what about the issue of Mr. Dreiser?
I think, I'll speak for myself, or I think in some sessions, we should have that resolved, the depositions, that will resolve that issue, one way or another next week, so.
So maybe June 1st too?
That
When
would,
did I pass, Mr. Fernandez?
You did, Your Honor.
that would be fine with me, Your Honor, and if Mr. Rice and I have a discussion, he wants, thinks he's gonna call his motion, we'll contact the court sooner than that. Is that all right with you, Mr. Rice?
Mr. Dreiser,
Yes, ma'am.
did you hear me? Like, is June 1st okay, Ms. Day?
We're out, Mr. Hill and I are out, but Ms. Day, I believe on June 1st could be there.
It's just a scheduling hearing, so,
That's fine. That's fine.
and then I need to know kind of where your team's at.
With Frank's,
Right.
we'll have a
Because
better
I don't
idea.
want to get too far into June, because there's a time frame that I'm out, then I'm back. I have a lot of trials.
We'll have a better idea next week. We're deposing Detective Johns Monday and Tuesday.
Perfect. June 1st?
Yes, ma'am.
Okay. So, Mr. Hathaway, June 1st, both cases, will be in 308.
Yes, Your
9 o'clock, Judge, or 8:30?
None.
Yes, sir.
actually, 9:30. I'm changing for a summer schedule,
Yes,
so
sir.
9:30.
Yes, ma'am.
Okay.
Thank you.
So thank you all very much. I appreciate y'all's hard work.
Thank you.
Work to adjourn.